Hello and welcome to Calm the Pharm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Another chapter today on our partnerships journey, and today we're going to talk about dispute resolution. Now, this shouldn't be as scary as it sounds. It is all about resolving a dispute that has arisen in a way that is efficient and effective and avoids other costly processes such as litigation through a court process. Every partnership agreement should have a dispute resolution clause in it, which sets out how disputes will be resolved. So this might include things like how will the parties commence a dispute resolution process? Perhaps it is that they have to negotiate in good faith in the first instance. If that fails, perhaps a third party mediator gets involved. And if that fails, then there's a few pathways available to the partnership. One might be that the majority partner makes the final decision, or the other one might be that if the other processes have failed, the parties are then at liberty to commence proceedings in the court system. So you need to think about how many attempts or stages there will be in an effort to resolve the dispute. If you decide that one partner will have the ultimate decision-making power, then it is important to think about how you can prevent that power getting in the way of a fair negotiation. And to do that, you would incorporate provisions into the dispute resolution clause around the parties acting in good faith and using best endeavours to resolve the dispute. That means that the partners do actually need to come to the table fairly and really try to resolve it, rather than sitting back and the partner with the power to make the decision just waiting to exercise that power. So that is one way, as I said, that you can have that resolution, I suppose, at the end of a stage process. If you are looking at involving any third parties to resolve the dispute, such as via a mediation, you might want to think about, okay, will we appoint a general mediator? And if so, how will that happen? Do each partner come to the table with a mediator in mind, or perhaps you specify in the partnership agreement who the mediator will be? Now, in these circumstances, and particularly with pharmacy, it is a niche industry. So a general mediator appointed by the Queensland Law Society may not be appropriate. So think about if the parties can't agree themselves who the mediator is, who is it going to be and who's going to appoint them. You can go so far as to actually nominate a mediator in your agreement. It might be a particular partner or other person with authority at a specific accounting or legal firm that has experience in this industry. So you need to think about what you're going to do around that. You have to remember that litigation is rarely the first mistake of a partnership. To get to the point of litigation between partners, it's usually the result of years of unresolved tension, but it can be avoided with a clear partnership agreement and, more importantly, a dispute resolution clause in that agreement. And those dispute resolution clauses essentially exist for the version of yourself that you hope never shows up. It sets out a clear process to be followed if a dispute arises. And if that process is not determined at the time the partnership agreement is prepared and the partnership is getting along amicably, then you can pretty much guarantee it won't be determined when you're arguing. So get it sorted sooner rather than later. Once you've thought about those questions that we've just been through and asked, you need to then consider how you're going to put those actions in place. So how are you going to draft this provision in the agreement? This is pretty straightforward. The first one is to implement your dispute resolution process. So set out that stage approach that we spoke about in the document and have that clear with timeframes around it, who's going to be involved, how the parties have to behave, etc. So that is putting the plan in place, and the plan is going to be different for each partnership. That's okay. What's key is having it in place. The second thing you should do is consider the impact, if any, of each partner's interest. So if someone holds a strong majority, do they actually want to go through that dispute resolution process with a minority partner? So let's just say the split's 90-10, so you've got a clear majority. Do they want to follow that process? And some partners will. Or would they prefer that at the very start of a dispute resolution process, they can actually make a call on a decision to save the partnership, obviously from going through cost, effort, anguish, time, etc., before it gets too nasty. So think about that, whether you actually want to go through that process or if your partnership is such that the split is heavily in favour of one partner. Maybe you want to circumvent that process entirely and have another way to resolve things. And as I mentioned, consider the appropriate third parties who might be able to assist with the dispute and decide on them, and think about how you want to document that in your agreement as well. A partnership agreement doesn't replace trusts. It protects a partnership when trust is under pressure. Handshake deals might work when life is simple, but pharmacy ownership is anything but simple. Many listening to this podcast might be guilty of saying, we'll sort it out later, it's all fine, we get along. But partnership agreements are actually what sorting it out later looks like. And if you haven't got around to sorting it out later, remember that the most expensive partnership agreement is the one that is never signed. So if you're in partnership or thinking about it, the question isn't if you need an agreement, it's whether you'd rather write it together or fight later. Protect yourself, your business, and your partnership. And remember that handshake deals only lead to headaches. Thanks for listening. I'll talk to you next week.